Well, Donna, first of all, thanks for having me. As the Deputy Director of Labor, I wanted us to express to you and CIG TV our gratefulness for allowing this interview to take place. Some of the grounds for some of their complaints is a broad area, the labor law, to be honest. The labor law identifies over 100 offenses. Okay. Predominantly, the predominant complaints that we actually get is unfair dismissal, severance pay, where people feel like their rights not to be unfairly dismissed have been breached, and they come to us and they make a complaint. And that's the predominant complaints that we get. However, like I said, is a myriad of offenses, from not paying wages, not paying overtime, that kind of thing. So it's a lot of offenses, occupational safety and health, many issues that they complain about. Well, first of all, when an individual, if they walk into the department, they'll be met with a very accommodating, smiling client liaison officer at the front desk. Because we know that when an individual is actually being challenged by whatever their circumstances are with a complaint, we try our best to be as accommodating as possible so that we can get the best information from them that we would require in order to do justice to the complaint or the concern that they have. So when they walk in, the first thing that we would do is we would get them comfortable, and then we would give them an inquiry preliminary form. We give them that opportunity to actually write out their information, write out the issue that they may have, whatever concern or dispute that they may have had with their employer. And then we analyze that information to see whether or not the information that they have actually put down on the preliminary form could substantiate any breach of the labor law. For example, we look first of all to see whether or not there's a relationship of employer and employee, because the labor law addresses that. And if that relationship does not exist, then we may have to look in other areas, and we may have to tell the person to consider looking in another direction for a resolution. For example, if the person was an independent contractor, for example, then the labor law in itself will not necessarily be the law that they may want to enforce against someone that they had an outside contract outside of an employment relationship agreement. So we make sure that the employer-employee relationship exists, and then we can move from there. Okay. So once that threshold has been crossed, then we try our best then to seek to mediate the actual complaint that has been made. Okay. There is always opportunities for that mediation to take place. Sometimes the employee, him or herself, will say to us, I would like you to speak to the employer. I really wouldn't want this matter to be progressing any further than us trying to resolve this. We appreciate when an employee tells us that, because then it leaves the door open to let us know that there's opportunities here to mediate this matter without it being taken to either a tribunal, if the tribunal has jurisdiction over the matter, or to the law courts, if the tribunal doesn't have jurisdiction over the matter. Once we contact the employer and explain to them the complaint that had actually occurred, then we invite the employer in for us to sit down and discuss the matter. We'll let the employer know the process by which we would follow if this matter is to be mediated, and if mediation has failed, what steps would be taken. For example, it may go to the labor tribunal for hearing, or it may go to the summary court for a hearing as a result of the complaint. If a complaint has been made, it passes the inquiry stage whereby it cannot be mediated. Right. Both the employer and the employee has hold fast to their views in respect of the matter. Then we inform the employer and the employee that we will now formally investigate this matter to put it either before the tribunal or to put it before the summary court. We collect statements Just as if any other criminal investigation. We collect statements from the individual. They sign that they have actually disclosed us the truth. We ask them for documentation, be it pay records, contracts of employment, all the documentation that would support or not the allegation. The investigation is, we explain to them that it's being investigated fairly, both for the employer and the employee. Okay. We have then a period of 30 days to notify the employer that we had received a complaint against them. And the law obligates us to then send a copy of that complaint to the employer, in addition to any associated documents, letting them see what complaint has been made against them, and invite the employer's reply. The employer then replies. We look at the whole case on its own to see what's the circumstances, and we prepare it, and the director then will actually make a recommendation to the labor tribunal that a hearing should be undertaken in respect to this matter because it cannot be resolved amicably. So that is basically the process up until the tribunal stage. Once it is passed to the tribunal, then the tribunal secretary has 21 days to notify both parties of this matter going before the tribunal for a hearing. When the matter reaches the tribunal, the tribunal hears it, and when they have completed their hearing, they have 28 days in order to give a reasoned decision to both parties involved. So that is the process if the matter goes to the tribunal. If, on the other hand, and we always reserve this protocol, this system in good communication with the Department of Public Prosecutions, that if we need to go down the road of doing criminal prosecutions, whereby putting a person before the summary court, then of course we will do that. We believe that we should be a friend of business for obvious reasons, but we will not be friendly with business because we have to administer the labor law, and we have to administer the labor law fairly. Well, certainly we do have that option for an individual to call, and we have our tip line. I'll provide that tip line to you later on, whereby they can call and they can give their information in that regard. They can also, through a friend, give anonymous information, communicate it to one of us, and once we are aware that the employee is concerned about not being identified, we have processes. We know how to manage that aspect of the information so that we can deal with it. Sitting behind all of this as well, we have an inspection and an audit unit that does routine inspections and audits on companies. It is not used in a vindictive way, but we have industries that we would audit, and the purpose of that is to assist them to be able to be compliant and to move forward best practices in the terms of a culture of compliance of the labor law. So it's all about assisting the employer and the employee so there will be a wonderful mutual enjoyment of the workplace, of the relationship that the employer and the employee will have. In all honesty, what I've observed since being there is that the complaints are not really increasing. And the reason for that is because we have undertaken the strategy of education. We've been educating employers and employees. We've been educating the public on what we are doing. We are partnership with them because we want that enjoyment, that mutual enjoyment, as I alluded to earlier. So I haven't really noticed that the complaints have increased. What we have noticed is that a lot of the inquiries that have actually came into the department, which could have escalated into a formal complaint, have been resolved through mediation. that is on the increase because we have been engaging the employer and the employee more in relation to it. Certainly. I mean, as I began the interview, I mentioned about individuals. We try to make them comfortable.
Right.
And the reason is because we have actually educated our staff that the individuals that come to the department, they don't have an issue with us. They have some other issue. So we got to be as accommodating as possible and understand them. So we put it in context. When we put it in context, then we can understand that the individual understandably is upset about their circumstances.
Right.
And once we explain to them that, okay, we do understand what is happening here, but you need to help us better understand, and the best way to do that is for us to allow you to calm down so you can tell us the best information so that we would be in a position to help you. And majority of times, those individuals are very compliant and understand. We don't contribute to their frustration. We believe that we should be professional with how we deal with individuals, irrespective of how irate they may appear. And at the end of the day, we give them a little pat on the shoulder and tell them, you know, we appreciate the way that you have actually spoken with us. We appreciate how you have delivered the information to us, and we will deal with this information as expediently as possible and as fairly as possible so that the whole circumstance could go back to normal as quickly as possible. So we keep in touch with them and let them know that, you know, you have not been forgotten. Because a lot of times, individuals get irate when they make a complaint because they don't get any feedback.
Right.
Is this pillar of silence that they have come against? And what we have been moving over the Department of Labor is to let individuals know that we're going to keep in touch with you. Okay. We're going to help you through this, and we're going to be professional with what we do. And that has been a significant move forward in the terms of professionalizing how we do business and letting individuals know that if you come to the Department of Labor and Pensions, your complaint will be dealt with fairly, expeditiously, and consistent with the labor law. Yeah, certainly. I mean, that has been a tremendous experience. And we all have strengths in different areas. And when you can pass that experience on, that practical experience, that academic experience, and let them see by undertaking 3 key areas, which is to tell them, show them, and do it. Because that is how adults learn. And once we form that relationship and they could see that, you know, you can do things a different way, you can achieve a lot more when you look at it this way. You know, this is how we can enhance the way that we do business, because it's all about image, it's all about reputation, it's all about making sure that we're professional with how we do business. Right. Then individuals, the officers in the department, the investigators, the clerical staff, every one of us included, will then be able to be front-facing with the public, speak to them professionally, and they understand that it's all about providing a service that we have all taken obligations to provide to the Cayman Islands public. And of course, a lot of this is far-reaching, because we don't only deal with Caymanians who would have been subjected to some perceived unfairness or unfairness in the workplace. We have over 150 nationalities in the Cayman Islands. And at some stage, some other nationality comes to the department to make a complaint. And we have to deal with them fairly, right across the board, because they have equal rights like anyone else. And that is the kind of professional approach that we have been inculcating within the department. Absolutely. Education is key. That's why we have put ourselves out there to do various labor law fundamentals, labor law 101 types of courses, and anyone who would want to be in a position to take advantage of that, of course, can give us a call at the Department of Labor and Pensions. Okay. And you know, we can make arrangements to facilitate that. But a greater understanding of the labor law is definitely key, Because what that does for the employer and the employee is to minimize disputes. The employer then can review the labor law and see how the labor law would address the particular issue. For example, many times an employer is right in the terms of terminating an employee where the employer has run foul of the labor law is the procedure, the process under which they have done it.
Okay.
And that is where the labor law speaks to these. You have to go about this termination a particular way. Otherwise, it would be deemed unfair. And everyone have a right not to be unfairly dismissed. Yeah, but it has to move with time management. You know, when all of us can do with more resources, but we got to try to work a little smarter as well. Sometimes we are our own enemies in that we don't provide enough opportunity for ourselves to review. What I have actually been doing at the Department of Labor and Pension with my investigators is we sit down every morning and have a chat.
Okay.
What are the issues? So that we can resolve them as we go. Team effort. Don't sit there and die in silence. If you have come against a brick wall, maybe you can't find a way to find whether or not this person is an employer or an employee. You know, bounce it off for someone else. Let's go in the think tank. Let's see what's happening and work together. And that's where we pull together the resources and utilize it and prioritizing the matters.
Okay.
Not that we're favoring any particular complainant or employer, but we all understand that priorities does exist, and there's some certain matters that are priority, then we try to deal with those issues. If, for example, we may get a complaint regarding occupational safety and health, whereby someone could get hurt and probably die as a result, that's a priority for us. We can jump at that because the uppermost thing is the protection of life. So we would jump at that and make sure that the workplace is safe so that employees and employers can go about their business and provide the services that they undertook to do. Well, first of all, the labor law deals with minimal standards.
Right.
That is a starting point. And you have a lot of human resource professionals out there that have a good wrap around the labor law.
Okay.
In addition to that, you got a lot of legal representatives that individuals could go and speak with them, and they can get professional advice and understand if the issues are so burning and so on. But the key is policies and procedures, workplace handbooks, guidance and so on, the education aspect of it.
Right.
So, and the employer need to revisit that sometime. Because a lot of times employers are too busy to remember some of the real key things that they have in those employment handbooks.
Right.
Is when the investigation begins that we look into the rules of the workplace and we see some of these issues and we bring it to the employer's attention. Sometimes it turns out that they're like, you know, I was just too busy, I didn't recognize what was happening. And that's good that they identify that, but what we have to do is to manage that process.
Right.
So the employer and the employee needs to work together as a team and create that environment for discussion when issues occurs in the workplace. That way, the labor department will not be the first stop.
Okay.
The only time that an employer and employee should come there is when the dispute has reached the stage where they can't come to any amicable resolution on the matter, and the only option then is to take it outside of the working environment and bring it to us, so we would have that independent look on it to see where we are, and if of course it cannot still be mediated, then the tribunal or the summer court to decide on what is happening. So what employers really need to do is to create that environment for discussion, that communication with their employees, and don't be too eager to use the fist. What they need to do is to have more discussions with the team. People burn toast for breakfast sometimes, but it doesn't necessarily mean that you need to destroy your kitchen. That is the object. But first of all, like anything else, when you move into a department, you hear a lot of war stories. Unprofessional conduct, poor performance, and so on. I have heard some of those, and when I have actually heard, I take note of it and look to correct or to advise on how we can work at the reputation that the department has. Because like I said, we want to provide a professional service. If someone comes there, we don't want to make them feel re-victimized. We want them to go away realizing that someone is going to do something about this. So in the terms of how the public see us, we would like to see the public to see us as a professional body, a department that has reputation, good reputation, and they can call there when the number is answered, when the call is answered, they are met with a very professional voice. They are met with professional advice. They are met with professional guidance. That they can say, you know, that department is a department that someday I would like to, you know, come there and work in that department to see what it's all about. Okay, that number is 945-3073.
Okay.
That's our hotline. And our individuals can call. They don't need to leave any name and a number. You can block the number. We wouldn't go as far as trying to trace and see who it is. It's anonymous in its truest sense. Okay. All we want is enough information to be able to represent the interests of the caller.
Okay.
That's all we need. In the terms of the department's number, the number is 945-8960. 945-8960, and that individual, they can call us, they want to speak to us, and we'll be more than happy to put them in the right direction or give them whatever food for thought, because we're careful about giving advice, but we'll give them information to consider.